Securing a lease on a modern apartment comes with its own baseline of stress: credit checks, income verification, and bidding against other applicants. But if you rely on an emotional support animal, you face a secondary barrier. You have to navigate tense conversations with property managers and the sudden threat of massive, unexpected fees. This friction happens mostly because property managers operate on outdated assumptions. They dismiss a renter's documented mental health needs because they view the animals strictly through the lens of potential property damage. Under the Fair Housing Act, an emotional support animal is a reasonable accommodation, not a pet. Because of this, standard building rules lose their teeth. Landlords cannot enforce strict no pets policies, nor charge monthly pet rent or upfront deposits. Arbitrary property rules regarding physical traits are also voided. A landlord cannot deny your accommodation simply because the animal weighs over 50 pounds or belongs to a commonly restricted breed list. These federal exemptions offer immense protection. Yet, getting a resistant property manager to honor them requires you to navigate a recent, highly specific shift in how the government applies this law. For years, the Department of Housing and Urban Development, or HUD, treated all assistance animals, both trained service dogs and untrained emotional support animals, under the exact same regulatory umbrella. This timeline illustrates a major regulatory divergence. On May 22, 2026, HUD's Office of Fair Housing and Equal Opportunity rescinded its older 2020 guidelines and split the legal path for assistance animals. Under the current rules, requests for trained service animals are considered presumptively reasonable. But untrained emotional support animals no longer receive that automatic presumption. Landlords are now legally permitted to scrutinize these requests through a fact-specific, case-by-case evaluation. This makes having legitimate documentation from a medical or mental health provider an absolute requirement. Because property owners now hold this localized evaluation power, renters have to stop relying on broad assumptions and instead adopt a strict, documented defensive strategy. So what happens if a landlord looks at your documentation, gives you a verbal denial, or insists that you pay the standard pet deposit anyway? Step 1 is to immediately transition the conflict out of verbal communication. You email them, state that they are denying a reasonable accommodation, and ask for a formal, written explanation outlining their specific reasons within 5 business days. Landlords hesitate to put a denial in writing if they know they lack solid legal footing. Demanding this explanation forces them to commit to a position, preventing them from shifting their story. If they do reply with a reason like, "We don't allow pit bulls," or "Everyone pays the pet fee," they have unknowingly handed you the exact evidence you need to prove a federal violation. Step 2 is to act in good faith. You proactively supply them with the active HUD enforcement guidelines alongside your medical letter, explaining that waiving pet policies for an ESA is standard federal procedure. During this interactive process, you must follow the golden rule of housing disputes: build a secure digital footprint. Save every email, text message, and lease draft in an isolated cloud folder. If a hallway conversation does happen, follow up immediately with an email summarizing what was said. Keep a daily tracking log of the exact dates, times, and context of every single interaction. Maintaining a pristine paper trail strips away the power imbalance. It transforms you from a vulnerable applicant into a highly prepared negotiator with undeniable proof. There are cases where a landlord completely ignores your documentation, brushes off the HUD guidelines, and still demands illegal fees. When that happens, you have a final, cost-free recourse. You can escalate the dispute by filing a formal federal housing discrimination complaint. You do not need an expensive lawyer to do this. The federal government investigates these claims directly through HUD's Office of Fair Housing and Equal Opportunity, entirely at their own expense. Submitting the HUD 903 complaint is highly accessible. You can enter the details and dates through their online portal, complete an intake interview over their toll-free phone line, or mail a physical copy with your printed evidence trail. Once filed, a federal fair housing specialist reviews the timeline. If the details indicate a violation of the Fair Housing Act, HUD opens an official investigation into the property. Receiving an official inquiry notice from a federal agency puts immense pressure on a housing provider. Often, the mere arrival of that document prompts them to instantly back down, approve the animal, and waive the contested fees. Understanding the strict legal boundary between a pet and an emotional support animal gives you footing. Combining that knowledge with an organized paper trail and the willingness to escalate federally ensures your right to safe, accessible housing is fully protected. For more deep dives into property rights and navigating the modern rental market, subscribe to the Real Estate Crunch podcast, our YouTube channel, and our free monthly newsletter.